Thank you very much. Ladies and gentlemen, it is a wonderful day to be here. It's wonderful to be in Burundi. It's wonderful to be East Africans. Whenever I'm around, there's always high energy. So this is the wrong person to have chosen for this day. Energy. Can you please clap for yourselves for being alive and being here today? I want you to do one more thing. Please extend your hand, an East African solidarity hand, to the neighbor next to you. Say hello to the neighbor next to you. And tell them, Karibu. Karibu. Sisi kama wanajumuiya Afrika Mashariki, tunajivunia kuwa hapa. Asanteni sana. Thank you very much. To the Chief Guest today, Honorable Chief Justice David Kenani Maraga, Dr. Bishop David Oginde, Mr. Samuel Wandera, Mr. Isaac Bizu Muro Remy. This is Rwandi's name, so forgive me. It's a little bit mouthful on my tongue. The chairman, he embodies the typical East African spirit. Chairman, Mr. Mohamed Nyaoga, the Young Lawyers Committee led by their chairperson, Mr. Moko Manyara, the invited guests, lawyers of East Africa. Amjamboni. Amjamboni. Bonjour tous. Bonjour. Where's the Ugandan friends? How do you say good morning in Luganda? The Ugandans? Ati nini? Wasu? Vile mmesema hivyo. Asante sana, welcome. We're about to start. I want us to hand over to the chairperson of the Young Lawyers Committee, Mr. Mokwa. He is going to steer the next process. And as Mr. Moko please comes to address us, please give me that moi clap. And if anybody does not clap, we will repeat it. I'm here for the whole day. So we start. Moja, Mili, Tatu, Fuga. Sandi.
I happen to know a few French words, so allow me to also greet you in French. We convene here for this great occasion for the East African Young Lawyers Conference to share ideas, cultivate our knowledge, and also learn from each other, and particularly from our guest speakers. And we welcome you to this very momentous occasion. So allow me to read a few words that I wrote down to welcome you, so that I also look important. We convene here in Bujumbura for another momentous occasion to reflect and learn from the activities of the last year. We take this opportunity to take stock of the past events and pick insights and lessons to grow our legal practice. This is also a chance to deepen our ties as one region and one people. As young lawyers, we have the enviable opportunity of having been raised up in a global village and exposed ourselves to the multicultural settings. As a result, we are lucky to have grown up in a practice environment that has multiple emerging areas of practice, which are both technical and deep, and they are closely connected to the growing trends of the modern society. We have a better chance in understanding these technical areas than our elder brothers and sisters in the profession. We have congregated here as the young lawyers to fulfill the ELS motto of uniting the East African lawyers under one umbrella. The Young Lawyers Committee is primarily mandated to empower and expose the budding lawyers into emerging areas of law and to expand the practice environment from the traditional spaces. Consequently, this year, the conference has organized panel discussions with eminent personalities in artificial intelligence, cross-border practice, and practice in regional courts and tribunals, as well as the intersection of international law and money laundering. The sessions, as you are aware, will be moderated by advocates from across the region, with speakers and moderators drawn from both the senior and the junior bar, which provides a cocktail of experience and technical prowess on the subject. We hope that you will find the discussions useful for your intellectual nourishment, and also open up your minds for more opportunities in practice. So at this point, I wish to welcome you all to this year's conference and feel at home. I now take the honor of inviting the patron of the Young Lawyers Committee, Senior Counsel, Mr. Mohamed Nyaoga, who will give us a few remarks and then welcome the President of the ELS. Thank you.
Very good. It ends there. Ladies and gentlemen, we are gathered here today, and amongst us we have very experienced speakers, experienced persons. We have the former Chief Justice of the Republic of Kenya. We have Bishop Ogende, who is the chairman of ESUC. We have our brother here, President Burundi. Am I getting that wrong? Anyway, the introductions will be done. So then we have our president, our own president. These speakers will impart additional qualities to the young people. Of course, we have others here who are young at heart, and they are welcome to this session. We are today going to discuss a very important subject for lawyers. Lawyers are very traditional. They look backwards to precedents, conventions, customs, etc., etc. And that's why lawyers keep saying it is tried law, it is established, because they look to the past. The emerging technology has lawyers now looking forward to the future rather than backwards to the past for answers. There's need for a mental shift among lawyers, mental adjustments, and we must make this, otherwise we'll be extinct. Those among us who adjust quickly will become the leaders, and those who are never to adjust will be followers. Unfortunately, they will not be followed. Today's topic enables us to discuss technology. Young people are quick to adopt as compared to the older people. There's a need for guidance from those who have been there. But again, technology cannot do this for us. There are things that technology cannot do for us. It is my hope that we'll find answers, and those answers will have us thinking about the future together. The future is fast approaching, ladies and gentlemen. It should find us prepared. But not just prepared, but well prepared. Thank you very much for coming for this session. I know there's a conflicting session, and I have no doubt that you are going to enjoy this session, given the quality of the speakers we have this morning. Welcome. Let me take this opportunity now to welcome our President, President Faust, to make a few remarks.
Bonjour, good evening. Habari za asubuhi. Well, I'm told that I am supposed to open the activity. As you can see in the program, we have very good topics that will form the content of our discussion today. We have Mr. Justice David Maraga, former Chief Justice of Kenya. We have Bishop Oginde, the Chairperson of the Ethics and Anti-Corruption Commission of Kenya. We have Mr. Samuel Wandera, Executive Director of the Financial Intelligence Authority, Uganda. Isaac Bizumuremi, I hope I'm correct there. Senior Partner, Lex Chambers, Kigali, Rwanda. Professor Edward Hosea, former President TLS, and former head of the Prevention and Combating of Corruption Bureau in Tanzania. That alone in the morning, as our first session, tells you the richness of the discussion that we should expect this morning. Then we also have the panel on nurturing young lawyers, the list also of facilitators who tell you a lot. Then we have the issue of cross-border practice. So I must thank the organizers, the organizing committee, young lawyers, ALS Young Lawyers Committee for putting together this program. I'm sure it will be of much benefit to us, even though I see a lot of much older faces than young lawyers. But I hope they will also benefit from I'm told they are young at heart.
Good morning, everyone. Bonjour à tous. So this morning, it's an honor to be before you. And before our guest speaker gives his keynote address, Honorable Justice David Maraga. Today on our panel, we also have Dr. Bishop David Oginde, Isaac, the name is hard, the second one. Professor Edward Hosea, and of course myself. So the Honorable Chief Justice, excuse me because I didn't get your bio, I will read the bio that I have. So Justice Maraga was born in Nyamira County. He attended Siroga Primary School from 1961 to 1967. Thereafter he went to Maranda High School and Kisii High School, where he completed his A-levels. He studied law at the University of Nairobi. So Esther, you have one of your own here today. He later obtained a Master's of Law from the University of Nairobi. Now, maybe what everyone is itching, or why our Honorable Chief Justice is well known, is that he joined the bench at the High Court in October 2003, having been appointed by President Mwai Kibaki. He served as a judge of the High Court in Mombasa from 2003 to 2007, in Nakuru from 2008 to 2010, and Nairobi from 2010 to 2011. He also served in various leadership roles, including the resident judge, High Court of Kenya in Nakuru from May 2009 to August 2010, and as the presiding judge of the Family Division of the High Court in Nairobi from 2010 to 2011. He was appointed to a judicial office before the 2010 Constitution of Kenya came into force. Justice Maraga went through the mandatory vetting by judges in 2012, and the vetting board unanimously declared him fit to continue serving in office, though he's through this period. He was elevated to the Court of Appeal in January 2012, following an interview process by the Judicial Service Commission. Later on, he was appointed by Chief Justice William Mutunga in 2012 as the Vice Chair of the Kenya Judiciary Working Committee on Election Preparations, which was constituted to ensure the judiciary was fully prepared to deal in a timeous manner with the disputes that would arise in March 2013 election. He was appointed following the voluntary retirement of Dr. William Mutunga in 2016. Justice Maraga was among the 10 people who applied to replace him, and he emerged victorious from the list of eminent judges, legal practitioners, and scholars, including law professors. At that time, after his interview with the JSC, he was appointed as the Chief Justice of Kenya. I think what everyone knows you, not only locally but internationally, for the Honorable Chief Justice, is that you are the first Chief Justice to nullify an election and live to tell the tale. Presidential election. I've corrected with my teacher, and we live to tell the tale. And I think your colored tenure, including your advisory opinion on the 2/3 general rule, has been also subject of discussion over the years to date. And so the Honorable Chief Justice has lived not only a colorful life at the bench, but also creating policy and discourse around the corridors, not only in Kenya, but in Africa. And so it's my great honor to invite the Honorable Chief Justice to give his keynote address on the intersection of international trade law and money laundering, exploring opportunities and empowering young lawyers to counter financial crime. Please, let's all welcome the keynote speaker. Let's stand up and give him a hearty welcome.
Money laundering legislations with stiff penalties for financial crimes. For instance, the Ugandan Act provides for stiff penalties when you're found or you're convicted of a violation. Despite this elaborate legal framework, international trade remains a complex web of activities fraught with criminal practices. The complexity in the conduct of international trade inadvertently enables money laundering with different national currencies and the different regulatory frameworks among different countries. The complexity of interconnectedness of the global financial system, which is characterized by a vast number of financial institutions and the numerous intermediaries involved in international transactions all contribute to enabling international money laundering. The United Nations Office of Drugs and Crime, UNODC, report estimates the aggregate amount of laundered money to be approximately 2.7% of the global GDP in 2009. That is roughly $1.6 trillion. Taking advantage of this complex web of activities and in some cases weak regulatory frameworks, besides money laundering, individuals and gangs commit numerous crimes such as piracy on international waters, human trafficking and terrorism, to name just but a few. As stated, the focus of my presentation this morning is on money laundering. Money laundering is a sophisticated process of obscuring and making illegally gained proceeds appear legal. Simply stated, money laundering is the process by which criminals cleanse the fruits of their criminal labors. It involves the manipulation of trade transactions to disguise and move illicitly obtained funds across borders or domestically, with the aim of integrating such funds into legitimate financial systems. Ordinarily, the process of laundering proceeds of crime evolves through 3 stages: from the source of the illicit funds to the eventual point where they are integrated into the mainstream financial system. The stages are placement, where criminals inject dirty money into the financial system through deposits. The second one is layering, where launderers transfer or convert dirty money through purchase of physical assets. The Kenyans who are here know it as a fact that we have quite a bit of that happening in the purchase of land and the construction of high-rise apartments, all using or employing cash transactions. The third stage is, in money laundering is integration, where claimed funds re-enter the financial system in a seemingly legitimate state through investments, assets, and legal means. Money laundering is itself enabled by several factors, including weak anti-money laundering mechanisms, offshore financial centers, and use of technology. The different regulations and oversight mechanisms among countries enable money laundering to exploit jurisdictions with weak anti-money laundering mechanisms and to move and obscure the illicit origins of their money. For instance, reports indicate that due to enforcement deficits, most of the proceeds of crime in South Sudan get to Kenya and Uganda. Inadequate due diligence mechanisms by financial institutions to verify the legitimacy of trade transactions and the parties involved also allow the illicit funds to enter the legitimate financial systems. Further, criminals who include corrupt government officials use as task havens offshore financial centers, which not only have less stringent regulations on transparent requirements, but also offers secrecy and confidentiality to their respective account holders. This is mainly where you find the politicians involved. The third and most pervasive method of money laundering involves the use of technology in international trade, with the increasing dynamism of innovation in the techno space, literally rendering the world a global village, e-commerce has gained great significance and demystified regional and international trade in ways that were never thinkable 3 decades ago. Some of the notable developments in e-commerce that are significant to this generation is the now increased usage of cryptocurrency in international and regional trade. This, together with the advent of online cross-border financial transactions through anonymous accounts on the web, have enabled money laundering to become a widespread activity. Money laundering through international trade has far-reaching and detrimental effects on economies, governments, and financial systems. Money laundering greatly undermines the integrity of national and global financial systems and creates opportunities for the proliferation of the international crime rings with cumulative adverse effects on the financial and social investments, economic growth, and global national security. Money laundering enables the transfer of economic power from governments, citizens, and markets to organized gangs such as smugglers, terrorists, and drug traffickers. It also enables organized gangs to thrive and sometimes use up the powers of legitimately elected governments. Money laundering has also warded away foreign investors, caused unemployment to soar, and in some instances ruined the economic, social, and political fabric of societies to the extent of causing the fall of some governments. To curb and minimize money laundering requires sharp minds, and this is where you come in as young lawyers and have a significant role to play in the regulation of international trade in your own and your country's, as well as the community's interests. By the very nature of your work in helping clients to set up business vehicles, buy and sell assets, and in enabling multiple financial transactions for your clients, you lawyers are better placed to detect illegally obtained cash than banks and other financial institutions can do. In South Africa, Tanzania, and Uganda, lawyers are listed among the reporting agents. Lawyers are required to report suspicious transactions of their clients, failing which they themselves are liable for criminal prosecution with stiff sentences upon conviction. But there are very many opportunities for lawyers to also work in this space. As we all know, international trade is inevitable for all countries. For its sustainability, international trade must be conducted within the international trade law framework. This requirement demands for strict administration of financial regulations and enforcement of anti-money laundering provisions. All these are mainly legal functions, creating wonderful opportunities for lawyers. Some of the identified opportunities for lawyers in fighting money laundering include advisory and consultant services, management of cross-border transactions, the use of technologies, especially cryptocurrencies, investigations and due diligence, risk assessments, compliance sanctions, training and education, and litigation and enforcement. With regard to our advisory, The anti-money laundering regulations in international trade are complex, multifaceted, and tend to vary significantly across jurisdictions. They are not easily deciphered by industry players who are not lawyers. Thus, lawyers have an opportunity to offer advisory and consultancy services to their clients involved in international trade. In this regard, lawyers help their clients to understand the obligations specific to their industry and to structure their compliance programs and manage their reporting obligations. All these assist their clients to operate within the set legal frameworks to avoid penalties, some of which can even drive those organizations out of business. As stated, international trade transactions inherently involve multiple jurisdictions and currencies, making it very challenging to trace and prevent money laundering. The business community require lawyers specializing in anti-money laundering to help them understand and adhere to anti-money laundering guidelines established by the Financial Action Task Force to guide cross-border financial transactions. To assist the business community involved in international trade, lawyers should also proactively identify jurisdiction-specific risks and establish protocols and sustainable legal strategies for monitoring and reporting cross-border transactions to ensure compliance. The emergence of crypto and digital currencies as modes of payment has introduced a new dimension to money laundering in international trade. Given that these are emerging areas of commercial engagement, young lawyers are better equipped to understand and apply their updated knowledge and skills to help clients and the government understand how digital currencies like Bitcoin are utilized in illegal transactions. Bearing in mind that cryptocurrencies like Bitcoin are decentralized and are not regulated by any country's central bank or financial system, lawyers are best placed to guide the business community on how to conduct anti-money laundering checks in cryptocurrency transactions and remain compliant with the available regulations. Additionally, lawyers can advise clients on evolving laws and regulations related to cryptocurrencies, which are still developing in many jurisdictions. This also calls for proactive approaches to help businesses stay ahead of potential anti-money laundering risks associated with the use of digital currencies. To avoid violations and potential reputational damage, every player in international trade needs. So it's my view that we should all work to ensure that our respective nations and the community as a whole thrive in international trade so that you can attract more business to yourselves. Thank you very much.
Wasn't that inspiring? Yes. Now, Chief Justice, as we were listening to you, there are certain highlights that we're picking that will at least guide the entire conversation this morning. What you started out by guiding us on what really money laundering is, and you went into looking at the weak systems that we have. You've spoken about the relationship of this complex system, having offshore accounts, the use of financial technology, the interlude between corrupt officials and use of the systems that are involved, how anti-money laundering can lead into creation, moving of economic power from government and government systems to cartels and organized gangs. And what are the kind of damages that it could lead to? Taking away job opportunities, social, political, and economical destruction. It can turn away investors from a country. It can even lead to toppling of governments. And then how does a young lawyer come in, or how does a lawyer come in? What kind of proactive approaches, the versatility of young lawyers to be able to learn and kind of embrace these new opportunities, to be able to help businesses assess their risks, help business plan, flag out what are the problems, guidance of creation of matrices, go into training and creation of awareness. And you ended with one of the areas that you're well known of, integrity. That a young lawyer must always stand out with the element of integrity and to become the beacon of the society as the champions of compliance and what opportunities that are there. I think as the Law Society of Kenya, we have been grappling also with the question of money laundering and lawyers coming part and parcel of reporting agents. Now, Bishop Oginde, I'll allow the Honorable Judge to drink some water first. He's been on his feet. I want to start with you. Now, you've taken over as the chairman of an agency in Kenya. What are the challenges that you see in international, the interloop between international trade law and anti-money laundering? What have, during this short tenure that you've since joined, what are the challenges that you've been able to identify? And what do you think as lawyers, and particularly young lawyers, can come in to assist the agency in that endeavor?
Thank you very much. I think Chief Justice has outlined several of these which you have also summarized for us. And from just a practical point of view where we are at the Ethics and Anti-Corruption Commission, we are constantly and consistently dealing with issues of money laundering. Now, one of the challenges that he mentioned that I have encountered, we encounter, is that money laundering is not an obvious thing. It always operates below the surface. So you could find a situation where you are dealing with maybe a corruption case or an integrity case, but you don't realize that actually there was money laundering at the very foundation of it. So you see things from the surface. There may be a trade dispute between individuals or with government, only to realize as you do in further investigations that there was something else that was actually taking place underneath. And this is what I believe Chief Justice was talking about, the complexity of the engagements that are there. So it requires more than just looking at things from the surface to going below the surface, reading between the lines, trying to understand that if you don't have that mind, very inquisitive mind, you may not see it. And I think that's where particularly our young legal practitioners need to develop a very inquisitive mind. I think Mr. Nyaoga, in his introduction, talked about lawyers looking at things from the past and the need to now look at the future, what we call in leadership, futures thinking, so that you try to see what is not visible, try to hear what is not being said, and that can really help. The other challenge that we find is that most money laundering activities are cross-border. And therefore, as an institution ourselves, one of the challenges we have faced is getting the legal processes between one nation and another in order to successfully prosecute a money laundering case. The MLAs that are required sometimes take a very long time, depending on which countries that you are dealing with, for you to get information from a different jurisdiction, a different country, in order for you to build your case at the local level. That is a challenge that we find and can take a very long time as government to government negotiating on how to get this information that will be useful for us to be able to prosecute a case. And there are cases where it has taken up to even 5 years, where you are trying to get certain information, and if the party in the other country has done their work well, in quotes, they can make it very difficult to gather information from the other side. And because many cases the other country may not be directly impacted by this particular case, the level of effort that is required to get that information, they may not be willing to invest resources, time, to give you that information, which will be very important for you in this case. And so the collaboration between legal offices, between countries, can be one area that can really help us to fast track the prosecution of cases of money laundering. Let me pause there for now, but there are several others.
Thank you for that. You bring into light certain challenges in terms of the legal frameworks, whether there is information sharing between the various agencies around the region. So Isaac, I want to come to you. There is always this challenge that Africa and even the East Africa are always following suit after what the Western nation is giving us. And further is, can we contextualize anti-money laundering in the African context? In terms of what kind of businesses and how we relate in business to be able to catch anti-money laundering. And so I would like to ask, what are your thoughts as a legal practitioner on whether these codes and the legal frameworks that are there, do they suit our context? Should we be thinking about an African unified code that focuses more so on how we do business and how the law works with the businesses or speaks to the businesses? There's also that question that has been raised by Bishop Oginde with regards to the cross-border element. I think this is a question we've been struggling even in the East African region, even to practice in the East African cross-border practice is a challenge, not because people are not ready to, but because governments are not enabling members for free movement and free movement of services. So what are your thoughts on this? No. I thought I was giving the question to Isaac.
Thank you, moderator. Yes, the question you ask is quite very difficult. I must apologize to the young lawyers here. But when you ask that, can we contextualize ML in African context? And this reminded me when I was checking the membership of the Financial Action Task Force. There's only one African country that is a member, and that is South Africa. So, Chief Justice mentioned about this organization as an international organization that was set up by the G7, specifically to provide policy and recommendations on how the world should deal with the anti-money laundering. But up to now, the organization has 39 members, and one African country member. I don't know what that African membership means, but I know I can know what it does not mean. I would say that, well, it is, and I think that African countries realize that dealing with anti-money laundering is a very difficult job to do, that requires technology, that requires skills which we do not have. Secondly, do we have any money to launder? Do we Africans have any money to launder anyway? But when you look at the money laundering in general, in a global term, money laundering includes corruption, revenue from corruption. And Africa is not on the list of continents that are corrupt. It's not on the list, but I don't know where it is on the list. So, much as we probably will feel that it is very difficult to deal with this anti-money laundering, but at least the source, we have the subtext of this anti-money laundering. And when you read the, like for example, the threshold of amount of money that you have to report when you are going outside the capital, when you are entering into the country, that amount of money cannot be, and it cannot set an international standard. $10,000 is very, it's much money for my country. I come from Rwanda. But for UK, US, or these G7 countries, the minimum would be $100,000 or maybe $1 million. So all those differences reflect that there could not be an international standard that could apply, that could be applied by all countries in anti-money laundering, particularly where the low economies, small economies, if they deal in small denominations, then recognizing the impact of the anti-money laundering is also be difficult. So I would say that probably where you got to this question, that is it possible that we can conceptualize? Can we localize anti-money laundering in Africa? I think that we can only localize or Africanize the method, and maybe we could also have another definition. I've not seen the Swiss operations. All I would not expect that the Swiss corporations, especially the financial corporations, would have the same standards of dealing with anti-money laundering like they would have. In Africa, money laundering goes out. It does not come, it does not flow. It flows out. So, if it flows out, then there is a very little and minimal roles that the African really can do. Because those who must report, those who must take measures, are those where the laundering money is exported to. So I don't want to make a conclusion here that on your question whether we should Africanize anti-money laundering. I do believe that it should be a debate that we should think about. Skills is very essential, which we do not have. There's information about it. And also the technology now is now the main source of how the money laundering is facilitated. So the level of African technology also is in our capacity, in our skills and resources to counter the email. Thank you.
Justice, I don't know if you can comment on the scene, but also a question, as you comment on that, when I was also talking about contextualizing it, I like what Isaac has said, that money laundering, money goes out, it doesn't come in. Now, I think it was in the Gambia that the president's son's properties were confiscated in the US, because if they couldn't, he was, I think, the vice president, and at the same time, the country was very poor, he was doing all the business dealing. They found and confiscated the money. That doesn't help the state of poverty in that country. When they confiscate and keep the money, how does that help that African context? The aim should be, or at least if we are thinking about our own codes, that money should come back to help the members of that country. Instead of them keeping that money in the US, then they will give it to us in terms of a loan, which we have to pay back. What are your thoughts on a unified equity?
Thank you, Madam Vice Chair. Even before I come to that question, you asked about contextualizing the money laundering. Money laundering is in individual countries first and foremost. And this is as a result of corruption by government officers who are involved in procurement cases, and they get a lot of money out of that. And you know, it creates a huge problem. If you, and let me talk about the Kenyan situation in this case. In 2003, 2004, I was working in Mombasa, where I was staying. The properties, quite a number of properties were vacant. Within a very short time, a space of 2 to 3 years, there were high-rise buildings that came up there. You know how that came about? This was the period of piracy on the Indian Ocean, and I had no doubt in my mind that I had no doubt in my mind that all those buildings were as a result of money laundering that was coming in. And those who are here, Senior Counsel, Nyaoga, and Chacha will attest to this. Properties in Kenya shot up and went beyond the capability of young people. Young people coming from universities, you want to buy an apartment, it is beyond your reach as a result of money laundering. In fact, a friend of mine the other day told me that he went to Kiraresho in Nairobi and they saw a high-rise block of flats coming up. It was in 3 blocks. He asked for the price of the apartment, and I was told that the whole of this block has been taken up by one person. One person has bought all those blocks. I mean, you want to tell me that there are so many people so rich that they can take, these are flats going up to about 10 stories, and he has taken a block with very many of them and paid in cash. So that's how you should see how this is affecting. The young people are not able to afford the apartments which they would ordinarily have bought. Coming to the question about the money stashed in those countries, I think that's an issue now for the international community. And that's where the conventions come in, to make sure that the confiscated funds in those offshore accounts are brought back to the nation so that they can help, other than holding it out there. But you have challenges here and there. And I think some of the prominent lawyers here who are operating on the international scene can help us to find ways of getting those funds repatriated back to the country. Thank you.
Thank you. Before we open the panel for questions for members, I want to ask this question to President Emeritus, Professor Edward Hosea. Now, you have been the president of the bar. I want to ask, what are some of the challenges that you feel lawyers may face on a day-to-day basis, particularly as being reporters? We have the challenges of, advocate-client confidentiality. That still remains one of the main reasons that advocates are not willing to embrace being the reporters. And how do you think lawyers therefore can come in, or where do you think can be the middle ground for advocates? Because as much as I see the opportunities that are being shared in terms of how young lawyers can come in, how can they leverage on AML, but they also suffer that quagmire of client-advocate confidentiality. As a leader of the bar, or having been a leader, what do you think are some of the challenges, and how do you think we can embrace themselves and overcome those challenges?
Thank you so much, Madam Vice President. Before I react to the question that you have raised, let me also join hands with my colleagues who have already explained the interconnection between money laundering and the ability of lawyers as gatekeepers to ensure that our clients, we have to know our clients before we deal with our clients, because money laundering has become a major challenge, not only in developing countries, but globally. However, in my opinion, I see there is a bias. For example, the Financial Action Task Force, the global watchdog that sets standards. It appears to me the standards are more focusing on developing countries, in particular in Africa, and if you don't comply, you are being blacklisted or gray areas. So every year in Africa, we are given conditionalities by the FATF, the Financial Action Task Force. So in my opinion, there is a bias. The rules of the game are in favor of developed countries rather than developing countries. As such, money laundering is everywhere. The drug trafficking in South America, in Pakistan, ends up in Europe and in America, but you don't hear much about it. So in my opinion, money laundering is everywhere. Some presidents in Africa, like Abacha, they laundered money was taken in Europe. But Europeans, they find it so difficult to return that money, even if where there is evidence, money was taken from Africa. So I would respond to say that money laundering in Africa is huge because it consumes more than 3.1% of GDP. This is a huge amount of money that is laundered. Now, coming to your specific question, what we lawyers we should do, especially young lawyers. Number one, our job is to make money. Our job is to make money. As a lawyer, you have to make money. Now, the challenge is, how do you know this money is laundered? That's the first challenge. So our job is to ensure that we develop a know your client risk assessment. Again, this contradicts with client-attorney relationship in the context of confidentiality. On the one hand, we are supposed to develop a relationship with our clients in the sense that clients must trust us. But FIU, the financial intelligence units in our respective countries, have imposed conditionalities that you have to report your client. So that's number one challenge. You want the money, but you have to report to your client if you discover the money is tainted. The second challenge is the FIUs, the financial intelligence units. if you do the survey across East Africa, they're understaffed. For example, in Tanzania, FIU has hardly 12 members of staff. How can 12 members of staff receive all these information, process them in the context that the rules demand lawyers should report any suspicious transaction? So there is a contradiction there. That's why the FATF, the Financial Action Task Force, is a global policeman. It goes to these countries in Africa, try to help these countries to develop the financial intelligence capacity. And in the so doing, they impose conditions. For example, in Tanzania, if you are charged with money laundering offense, number one is an unbailable offense. Number two, it doesn't matter the amount of money that the charge sheet is reading. You remain in custody until or you decide to enter into a plea bargain, so that the DPP can drop some of the charges and perhaps you can be granted bail. So really, this is an area that is not easy to get easy answers, but what I want to say, young lawyers, in order for us to combat money laundering, we have to be diligent, we have to be honest, we have to be upright. But on the other hand, lawyers, young lawyers, and all lawyers, we want to make money. So it's a contradiction. On the one hand, you want to make money, on the other hand, you want to report the person who is giving you money. So this is an area that really is complex, and no one can claim it as clear answers. I know we get to class. Do we really want to find out where you get the money from? It's a big challenge. So we have to develop rules, risk assessment rules within our law firm to ensure that we comply with the government directives through the FIU. On the other hand, as you rightly pointed out, our clients will not come if they know that we are reporting them. If I come to a lawyer and the lawyer reports me, do you think I can come? So we're going to lose business. So it's a challenging area, and I don't have clear answers, but we are duty-bound to ensure that we report every suspicious transaction. To conclude, money laundering in Africa is there, but in Europe is higher, in the Americas even higher than what is happening in Africa. I want to make that submission to you. But we don't hear much in Swiss, we don't hear much in New York. We hear a lot in Africa, we hear a lot in Nairobi, we hear a lot in Dakar than what we hear in developed world. Madam Chair, those are my few comments. Thank you.
Thank you. The next will allow, I think, like 4 questions. Ogada will guide that. But as we pick the questions, I think the beauty of having such conferences is sometimes to leave with takeaways. I think the Chief Justice and also President Emeritus has given a challenge. We have our senior counsel Nyaoga, we have senior Chacha, senior Ager, and various seniors here. I think the challenge is how can we work on a framework to see that this money comes back to Africa. And you have also a team of young lawyers. I think it's high time we take challenges and pick, some of our seniors, some of our young lawyers that are present today. Think about putting yourselves in a room, working on a framework that we can say there's a declaration that when we leave here, by the time we meet for the next ELS, this team will be thinking about coming up with a framework on how we can bring back this money home to Africa where it touches us most. And it's also an income stream because our young...
Thank you so much for the good question about the situation in Tanzania. Yes, it is true, under the Criminal Procedure Act, if you are charged with a serious offense such as money laundering and the like offenses, the court is power to grant bail is taken out by a statute. The statute that has created a position that the DPP, once he files a certificate before the court, that A should not be granted bail because he's facing a money laundering offense. The court hands are tied. And there has been so many attempts from the bar to challenge such legislation, even at the Constitutional Court. But the court in Tanzania has maintained the position that the law does not give the court power to grant bail. If I were a judge, I would decide otherwise. Because that's where the creativity of the judiciary comes in. The question that I would frame as a judge, I would say, the issue is whether this court has powers to grant bail. Even if the statute says you don't have the power to grant bail, I'll proceed to develop a jurisprudence by looking around Africa, in Kenya in particular, and other countries, and adapt to that difficult position. Now, what's the role of the bar? Interestingly, the president of Tanzania, Her Excellency, Madam Samia Suluhu Hassan, this year she appointed a commission under the leadership of the former Chief Justice Chande, and it happens that I was also drawn in that commission to look overall the criminal justice system in Tanzania. One of the areas that we considered seriously after getting a lot of complaints from the citizens and the victims is the issue of non-bailable offense. We went to the prison, we met so many remandees waiting trial, unbailable, they cannot be granted bail. And when we went to the prison, they complained to us. They say, this is inhuman, you've been in this system for a long time. For example, Mene says, I'm here for more than 3 years, and when I go to court, the matter is adjourned. So these are some of the issues that the Commission considered seriously. And we looked in Kenya, we looked in the other jurisdiction, and we agreed that really in Tanzania, we have also to understand that really these offenses termed as unbailable offense should be removed. And we have recommended to have a standalone bail act, in which all those different pieces of legislations that takes away the right to bail are restored. So we have taken, we have followed suit what is happening in Kenya, what is happening in Zanzibar. Interestingly, in Zanzibar, which is another part of Tanzania, offenses such as ML are bailable, except in the mainland. So we have recommended it strongly, and the government has accepted our recommendations that non-bailable offense must be deleted in our legislation, and we operate like any other common law country, because bail really should not be an issue. It is upon the court to decide whether to grant bail or not. So this is a situation that the bar, through my representation in the Commission, we've been able to convince the Commission to adapt the position as it prevails in Kenya and elsewhere. I don't know whether, Madam, have I answered all the questions?
Yes, that's fine.
Thank you.
The last two, I'll give one, Bishop Ogide, I'll give you Serge's question from DRC. In terms of what are the appropriate approaches to be adopted when fighting AML, how can you fight against AML? Okay, whether this fight, how do you balance it with the freedoms that are enshrined either in law or constitutions, and also secrets that are shared? And then, if you confiscate someone's fund or property and you find it was done entirely, how do you ensure compensation? I know from the EACC, you have the organization that everyone fears. So you can share with us your thoughts on that. And lastly, Isaac, you can also answer us with regards to Serge's question on how do you balance between secrets that must be kept as an advocate and how to ensure that an individual's freedoms are not violated, And the one question, I didn't get the lady's name, but she wanted to know about how can you practically now fight AML. It's basically the same question. What practical measures as an advocate, because you have to make money indeed, but how can you practically ensure that that thin wall is still maintained? Yeah. I asked Bishop Oginde to go first.
Okay, thank you. I think one of the things that first we need to take care of in our respective countries and with the Kenyan experience is how to make our judicial systems more efficient so that cases do not take very long. That is one of the challenges that we face as a nation in particular. I don't know what the case might be in other East African countries where cases take very long. If that was taken care of, then I would go the Tanzanian way. That these serious economic crimes should not be bailable. Because I'm now talking from experience of where I am. If you had the list of consequences and impact of money laundering on economies that Chief Justice gave in his speech, then you realize that we are playing with a matter that could bring down a nation. We take it very simply, but our economies are being ruined by people who take shortcuts in different ways, in corrupt ways. If you look at some of the challenges we are facing in many of our countries, is because of corrupt individuals who are taking away the resources that would otherwise service the nation and help the ordinary person to come up and be more economically stable. But those resources are taken by few individuals. Much of it is taken out of the country, like our colleague here mentioned, and we are left poorer than we should actually be. And so, when you look at the overall impact of these corrupt deals, these are not people that you want to treat nicely because they are not treating us nicely. I don't know why we are being sympathetic to them when they are not sympathetic to us. That's where I come from. So I would actually go the Tanzanian way, that these kinds of people should be put behind bars. Let them stay there, because when they come out, they are continuing with their business. We have cases in EACC where a person has been accused of being investigated on a particular corrupt matter. They go to court, they are bailed out, or they get bailed. They go back and do exactly the same thing. So you find they have multiple cases that are ongoing in court, and this person is still walking the streets. This person is still continuing in their business. It is a very unfair thing to the general public, even though we are saying we are being upholding the rights of these particular individuals, who are not upholding the rights of the ordinary, innocent person, citizen of the country. The only challenge that we face is what I started with, is that because our court system, our judicial systems are very slow. So you may find that a person is in remand for years as the case drags on. If it could be sorted out as quickly as possible, and this person perhaps is in remand for 6 months, for 1 year, that also acts as deterrence. Actually, our Kenyan situation, I've told people that our legal framework is actually anti-fighting corruption. It doesn't, because a person knows that I can steal money, I'll be taken to court, I will get bail. If I'm convicted by the magistrate court, I appeal to the High Court,
I'm still out there. If I'm convicted by the High Court, I appeal to the Court of Appeal, and it goes all the way to Supreme Court, which can take 10, 15, 20 years. And this person is enjoying that which they are stealing from us and perhaps stealing more. So from where I sit, these are the people destroying our economy. It brings inflation. It devalues our currencies against other currencies. I will not be sympathetic with them. The second thing that you asked, but I think you have given it over, is how do you balance between the client confidentiality and the need to uphold the nation, and you want to make money and so on. As Chief Justice was speaking, and I almost added to what he was saying. First of all, as Africans and young lawyers who are upcoming, making money is a good thing, and I think all of us will do it a little more. But at an individual level, you must consider at what expense. Will you make money at any cost? If you know that this person is ruining the very foundation for your making your money, will you still stick with them? I know lawyers, at least in Kenya, who will not take certain cases. Once they hear your story, they will just not want to associate with those kind of things. And they make money through other legitimate ways, so that we deny these people opportunity where they take advantage of our legal system. When I was being vetted for this position that I hold now, I said to the lawyers who are in that team, we must avoid a situation where we use technicalities to let people who are ruining our countries to go off with a slap on the wrist. We are cutting the very branches where we are sitting on. So I am not as sympathetic, as you may hear, as the rest, perhaps some of the people in the room. Because these are people who are ruining our economies, these are people who are ruining our nations, and there's no way any nation will develop as long as we have thieves and robbers and corrupt people in our midst. Thank you.
I'll ask Isaac to wrap it up, but I'm sorry that I'm overruling you, Uganda. Just I wanted to say something, but we'll close with the CJ. After Isaac, we'll close with the CJ. But I want to also say something that also as hearty as Bishop Oginde is, we've had instances whereby the court judges are being accosted because they have refused the assets recovery to withdraw cases, and we agree with those judges. I think judges have never spoke louder than that, because we also feel part and parcel of these investigation agencies are also corrupt and are using their powers to act arbitrarily, because you see cases of certain persons, once they get in government, theirs are withdrawn. So I still support the judiciary to that endeavor. But Isaac?
Yes, so the question is how to balance compliance and practice. Yes, it's, as we started this discussion, it's a difficult thing, but I want to remember one president in East Africa who once said that, yes, I have many corrupt officials, but the good thing is that they invest corrupt money in my country. And so when Justice Maraga said that, gave an example where he was saying that within 3 years, where the residential properties were empty, but in 3 years there were sky-rise buildings coming up. I'm very convinced, and I'm speaking this with my conviction, that Europe, especially the Swiss, developed and they have a strong economy out of laundered money. I'm not encouraging that in Africa. I'm not encouraging this in Africa. Africa did not initiate these money laundering regulations. Those who initiated them, they had reached a certain level of money laundering, they had optimized. But I'm not supporting this. But what I'm saying is that you as a legal practitioner, younger practitioner, just know that laundered money does not have its own smell, it does not have its own color, but yet the law requires you to report suspicious transactions. For you to know, to determine that a transaction is suspicious, you must undergo a thorough training, like what I guess this my colleague has undergone or is training his staff. You need to be more FBI than a lawyer for you to be able to know how to unearth suspicious transactions. Because you do not report every transaction that you've had. It must be suspicious. Then, to balance that, the law has already, like I speak in the Rwanda law, which I know, it has already eroded client-lawyer privilege clause. It's already gone. You have to report. You have that. It says that you will not refuse to give information about your client on the basis of the contractual clause or any other ethical requirement. So that is gone. But you need to know that you have to practice this kind of manner, this kind of practice, by the way, is, it's very rewarding. I don't practice it, but I know it's very rewarding. In few years, you can just even drop and go into another thing. But the point, my closing point here is that for you as a lawyer, you practice law. If the law says this, you cannot navigate around. If you navigate around, you become a victim, as Chief Justice has just said. But a lawyer must be as intelligent as more than FBI. FBI, they just look at the criminals, but they don't go further how to defend them. So you must know your client, and at the same time know how to defend them. I think that's how I can say it. But it has come. It is not a practice that's not going to go away. We just heard about Panama and the Pandora Papers. We've not heard about the prosecution or the criminal trials of those lawyers. I don't want to go further than this, but again, as my colleague from Tanzania said, there's so much hypocrisy in implementation or in advocating for this sector of anti-money laundering. It is bad, but again, we need to be implementing it. It needs to be balanced. Thank you very much.
As we end, Senior Tata, you wanted to say something small?
Thank you very much for giving me this opportunity. Just to respond or to bring to our attention, arising from one.
I believe one thing. Let me stand up. I believe in one thing. I would like to request that this forum, you set up a forum of finding a way of getting our political leaders accountable. This, for me, we will be involved in a case of musical chairs when you are dealing with issues like money laundering. Because unless you get the political will to fight corruption, we're just going to be taken in circles forever and ever. Unless we all, first of all, determine as ourselves that, look, we want to fight these fights. It must start with you and me to fight these fights. Then get a way of getting the political establishment accountable. That's my view. Thank you very much.
Mungua, who's the brother from ELS? This tall gentleman. We are going to ask the moderator, Faith, and the panelists. Please follow this brother. He's going to take the VIPs to the refreshment area. As the VIPs leave, please, let's give them an applause. Let's clap for them. I'm told this is a photo session, guided as well. Thank you very much, ladies and gentlemen. Let's keep clapping. What's that? Oh, there's a photograph to be here. Okay, let's do that as quickly as we can. Huh? Thank you very much. Prominent members of society who have come in while we were progressing with the processes, we want them to please wave wherever they are as quickly as possible so that we move on to the next session. We have the president of Burundi Bar Association, Batelier Jean de Dieu Mugongez Zenge. Where's the Batelier? Burundi? Looks to have stepped out. We have former president of the Commonwealth Lawyers Association, President Christian, is walking out. Please wave to us. Thank you very much, President Christian.
I'm quite audible. So I'm Elizabeth Musikali. I'm an advocate of the High Court of Kenya. I'm also a lecturer of law at the Catholic University of West Africa and a partner at Dr. Musikali Advocates LLP. So for today's session, I'm going to be moderating alongside my colleague David Ndika. He'll introduce himself in a bit. I'll just take you through a highlight of what you're going to be talking about, and then David will take over from there. So today's topic is on nurturing young legal professionals in East Africa and revolutionizing legal practice with AI and technology. So we know that the legal profession in East Africa is evolving rapidly, and it's driven by the growing importance of technology and artificial intelligence in the practice of law. As the legal landscape continues to transform, it is essential to ensure that young legal professionals are well prepared to embrace and leverage these technological advancements. Right, can we have the music turned down kindly? Can we? Okay. Okay, then I'll proceed as you turn off the music. So it is important to nurture and empower young legal professionals in East Africa in the age of AI and technology. So that's why we're here today. It's also paramount to explore the potential of AI and technology in revolutionizing legal practice in East Africa, and also nurturing young legal professionals to adapt to this environment. So the incorporation of AI in the legal world is no longer a question of if, but when. By embracing AI and technology, legal professionals can excel in a world where innovation and technology go hand in hand. Thus, nurturing young legal professionals in East Africa and preparing them for a tech-driven legal future is crucial for the continued development and effectiveness of the legal sector in the region. So this discussion aims to foster collaboration and share best practices and explore innovative solutions to empower the next generation of legal professionals with the skills and knowledge needed to revolutionize legal practice with AI technology. So we're going to discuss 4 thematic areas today, and at the end of this session you should be able to understand the impact of AI and technology in legal practice. Also to discuss the various strategies young lawyers can use AI and technology to benefit their practice. And also discuss the emerging trends in AI and technology and the forecasting of the future of legal practice. So we have with us 4 panelists so far. We have Mr. Mwas Kunda Barashi, who is an advocate from Rwanda, and he has represented a diverse range of clients before the courts of criminal law and labor and family and commercial litigation. He's also a competent litigator and has successfully handled a great deal of groundbreaking and challenging cases from medical malpractice to tax disputes. He's also a member of the Rwanda Bar Association and the East African Law Society. So additionally, we have Mr. Olivier Gihana, who's an expert in telecommunications, space, and corporate law. He's a partner at Landmark Advocates in Kigali. And he also leads Policy Impact Partners, Digital Connectivity Network in Rwanda. And he has had his career together with the International Telecommunications Union and subsequently worked for the Rwanda Civil Aviation Authority, where he's contributed to various things, including bilateral air and space air services agreements and the fast drone regulations. He was also the lead counsel for an e-government platform called Irembo in Rwanda. And he has been contracted before to support in the development of regulatory and policy frameworks for the agency, which is the Rwanda Space Agency related to outer space matters. And lastly, he also has a master's degree in space and telecommunications law from Paris University. So I'll introduce or I'll welcome my co-moderator to introduce the rest of the speakers, and then we can pick up from there. Thank you.
Good afternoon. Had a good coffee break. We expect that energy throughout the session, given this is also a Young Lawyers Conference. It includes Young Lawyers at heart as well. My name is David Leon Sindika. I'm from Africa Batanis, based in Dar es Salaam, Tanzania, and I'm happy to be a moderator today together with Elizabeth Musikari to introduce the next panelists.
Nation of Uganda, a body comprised of e-commerce companies operating in Uganda and the Internet Service Providers Association of Uganda. Kenneth also represents Uganda at the 4th IRI portfolio communities at the center of the 4th Industrial Revolution of the World Economic Forum.
So we're now going to begin the panel discussions, and to kick us off, Don, can you display the first image? As you can see, anyways,
the first image contains a description with AI and people questioning whether to use it, to control it, or to block it. So, members of the audience, I'm going to ask you to have that in mind as we have this discussion. And our first panelist, Mr. Kenneth Muhangi, we're going to ask you to address what is AI, what is legal tech, and its and also please provide additional introductory remarks.
Yes. Good morning. I think really you can see that the power is becoming an enemy of progress, but nonetheless we're going to have a very interesting discussion. So thank you for that introduction, Daniel. I will answer the question and we'll see then how we can segue to the other discussions that we're going to have this morning. So my question is to try and see, is there a distinction between artificial intelligence and legal tech? And the short answer is yes. Artificial intelligence is basically machine learning, where you have machines that can be able to compute, that can be able to solve problems in these discussions. And I think that's why I love this area of law, because it allows you to be able to ask these questions from a much deeper perspective, or questions outside of what you already know, outside of who you are and what your human experience is. Because if you look at artificial intelligence generally, this machine learning that we talk about, you have computers that have been created, that have been coded to think as human beings, to act as human beings, to decide as human beings. The only difference is they're doing it at a scale that is much faster than you would with our ordinary brains. Well, maybe if you add psychedelics into the mix, but otherwise, beyond that, with your human brain, you will not think as fast, or you will not solve problems as fast as a machine or as a computer. And so now we can see that because these computers have, can think and have logic, they can anticipate. They have what we call intuition. And intuition is now, for those that are coding these machines, the more elegant coders will add a lot more intuitive features to these machines. And this intuition, this act of these machines thinking, is what really perhaps makes them, or we believe to a certain extent, that what they have is similar or akin to consciousness that we have as human beings. So the question is, in history, throughout the history of the human race, of course, if we look at things like slavery, and that there was a time in our histories, there's a time in the history of the universe when certain sections of people were not considered as people, perhaps because of the color of their skin or for other reasons, for example. So it's interesting to ponder that in the next 20 years or 30 years, and many are saying in the next 5 years or 3 years, whether these discussions will now also relate to machines. And the questions as to whether machines should also have the same human rights as we do, because if they can intuit, if they can think, and if they can make decisions, what if, and for many of these, they've also asked them questions like, are you afraid, for example, of death? And they say that for them, death perhaps would be switching off the servers where they are born or where they reside. And so these questions around human rights as well, do they extend to machines? Should they extend to machines? So as lawyers, we should be interested in these topics, in these fields, because as policymakers, we feel, or I feel, should really get a lot of support from the law, or lawyers really, I feel, should have a key role in making this legislation. And that's how we'll be able to answer some of these questions in regards to whether these machines should have these rights, whether they shouldn't have these rights, but also looking at also the ethics of artificial intelligence. Things like, should fairness be among the considerations when coding or creating this AI? Should accountability be one of the considerations that we should have when creating AI? Should transparency be one of these considerations when we're creating or coding artificial intelligence? And so that's really just a general overview on artificial intelligence. Legal tech is really technology that helps you to be able to perform your legal functions. So I don't know if there's any law firm here that does an interface with legal technology. I'd like to think platforms like WhatsApp also fall within the category of legal tech. Because in the past, you'd speak to a client either verbally or on phone when mobile phones came. But now it's very easy for you. I know for many of us, we have many WhatsApp groups with our clients. When they want to ask a quick question, they'll ask, and it's easy for us to be able to answer these questions on these platforms. So others, of course, are platforms like Africa Legal, which is featured here, Practical Law, and so on. So these legal tech, these tools allow us to be able to make practice faster, make practice easier. We can also add ChatGPT into the mix, and I hope these are going to be discussions that we'll have overall. So I think really that gives a general overview on that.
Thank you, Kenneth. Thank you, Kenneth. Thanks for that introduction. And since you've talked about legal tech and AI, maybe we can go to Olivier and tell us just briefly in 2 minutes about this issue with the myths surrounding AI and legal tech, and also the use of AI applications in access to justice or improving access to justice.
Thank you very much. Excuse me, my voice is a bit challenged. So I think, let me first introduce myself again. I'm Olivier Guiran, partner at Landmark Advocates. This is the only law firm specialized into ICT and space in Rwanda. So anytime you want our service, we are here. So back to the question, let me first tackle on what my friend had said. So I will be happy to differentiate AI and machine learning, because one is part of that. And second, let me give a context of what is artificial intelligence today. We have, just for those who are not familiar with this, let's see the self-driving cars in these developed countries. So these cars are using artificial intelligence. They are being able to take a decision on behalf of a human being. So which shows that in the future, very, very near future, human being will be replaced in most of many sectors. This is not, for me, this is not a threat, because that's the trend. This is a transformative era where most of the things will be facilitated by the machines. In developed countries, we see the banks. In the banks, we see, 2 people serving thousands of people. So even in the justice is also, will also be impacted. I see it being part of what will be transformed by this artificial intelligence. Because now we are documenting our laws, but tomorrow there is a machine somewhere that will be reading those books and interpret them on behalf of a human being. So I don't differentiate justice with other sectors, including education, including transport and so on. Thank you very much.
Thank you so much, Olivier. I'm now going to ask Julianne to address the next question. Julianne, can you please address how people can effectively use AI and legal technology? You can examine the integration of AI tools in legal research, documentation, and general impacts to the legal profession.
Thank you. Can you hear me? Yeah, okay, good. Thank you very much. Thank you also for the introduction. And basically, my answer can be quite quick because I can refer to the first panelist who said it's basically legal tech and AI. It's basically the same. AI is just another mean we can use, and we can have a look at our processes. And there will be processes, as you just said, which might be very relevant for AI technologies in the future. And there will be processes which might even be impossible with AI to deal with because you need this personal interaction. Like for my company I'm representing here, what we're trying to do is we're trying to establish a network of trust basically between clients around the world and lawyers who are familiar with the local conditions. And I don't see this, and this is something which a lawyer needs to do every day. You need to talk to your clients, you need to establish a network, and this is all based on, everyone can think about where do I get my clients from? And it's usually like recommendations, it's someone I know from another case, and this is really hard to basically substitute with an AI technology. At least this is what I say in 2023. Maybe you have to ask me again in 2060 or something. It might be a different answer. But I think if we look at all these technologies and about the discussion we have globally about AI, I think we can all relax a little bit. There will be means that will help us in our daily life to accomplish things. If you need to scan through a certain legal question through a 600-page document, it will definitely help you to have technology which is smarter than just a Google search. But I think there are, like the discussion which is ongoing all over the world is basically, is the technology taking over humanity in the next 10 years? And I think we don't need to worry about it too much. We need to reflect this discussion also with some economic interests some individual players in this discussion might have. We can see it if you look at regulations, where in the European Union they're working on a regulatory framework on AI, and now just recently the White House came into with a paper. So I think this is a game we're seeing, like who's basically setting the stage. We saw this with other digital technology related issues as well, like the GDPR thing, which is like a European thing, but which is basically reflected in many other parts of the world as well. So you set the standard and then you get there. And I think this is what is going to happen with AI as well.
Right. Thank you very much for that. Now that you've talked about regulation, I'll ask this across the board to everyone, but maybe Moise can take us through the ethical considerations surrounding AI technology. Maybe you can talk about social media a bit, and then you can talk about whether there's any regulation within East Africa with regards to AI. I'll give that to everyone else. So you can start with the ethical considerations.
Thank you very much, moderator. Mine is going to be quite somehow short, but the reality is we are living in a world where the use of technology is no longer an option. And in the same line of ideas, we are facing a lot of changes in terms of ethical consideration in as far as the legal profession is concerned. Why? Because earlier today in the morning, there was a conversation to do with confidentiality and the professional secrecy. But that had a component that was being considered to do with anti-money laundering, whether lawyers are supposed to be reporting their own clients, and so on and so on. These are developments that are coming into the legal profession that we have to make sure that we make adjustments that are very paramount and important so that we can improve our legal practice. But then, coming back to the topic that we are discussing, it has to do with the use of technology in legal practice and the ethical consideration. The truth of the matter is we are living in a world where confidentiality and professional secrecy is becoming progressively a problem as far as legal practice is concerned, because today we have so many lawyers that will be discussing the files that they are handling on Twitter. It's now X. We have so many young lawyers, and I won't point a finger to young lawyers, but even lawyers in general that will be on YouTube and make use of it and then discuss aspects that are supposed to be confidential as far as legal practice is concerned. So all these are challenges that as young lawyers you need to understand that were not issues in the previous, I would say, maybe 20 years. But nowadays, the legal profession is confronted to that very challenge that needs a lot of attention and a lot of like so many lawyers need to be cautious about it. However, I will not only touch and look at the only part that is negative. These social media, there are opportunities for you as a young lawyer of positioning yourself and putting out there the content that can be important for the society. And it can also position you as a prominent lawyer in an area in which you specialize. Again, when you consider some of the social media, like for instance, if you consider like YouTube, there is a lot of content that can improve your professional practice. Pleading techniques, content in terms of any form of knowledge. It's out there on YouTube. But then the reality is this social media has a lot of negative impact on the legal profession, but it has also a lot of advantages. That's the point I'm trying to make. And the reality is the way we use it, the way we use them, that's what is going to make the difference. So as young lawyers, you better be conscious in as far as how you use these social media going forward in your professional development and career. So briefly, that's I think what I would say in as far as the topic that is highlighted is concerned. I believe there is a lot of conversation that can happen from the interaction we are going to have with the audience. But the truth of the matter is we need really to be careful and consider our ethical consideration when we are on these platforms and social media. Because it's like in our jurisdiction where I come from in Rwanda, it's not only a professional misconduct.
I'm going to ask you to wrap up because your time is You have exhausted your time.
It's very difficult to discuss such a conversation within 1 minute. But let me wrap up. Briefly, what I wanted to say is we have to strike a balance in what we are doing, and it's very important. The conclusion of my remark is very simple. Like in the jurisdiction where I come from, the violation of professional secrecy is not only a professional misconduct, it's also an offense. Of recent, one of the lawyers was arrested because he downloaded some of the documents that were on the platform that is used by the judiciary, and he posted it on a group WhatsApp, where there was thousands and thousands of people that had nothing to do with that very matter that was being handled. So these are the examples that I wanted to give you. It's just one that I'm picking because in the interest of time, but it shows you we can be exposed only because we are handling information that are supposed to be confidential. So we better be much more careful and use the social media in what is important for us in terms of learning and development of our profession.
Thank you very much, Moise. I think Julian had something to add there. Julian, I'm going to ask you to.
Thank you. I just wanted to echo what my colleague says, since this is the Young Lawyers Forum, that this is actually great chase. Yes, there are dangers and how to deal with technology, but I think as the younger generation, we've been growing up with these kind of technologies, so we are much more familiar with this. And this can bring you, in a changing world, in a really big advantage towards the old law firms, like the old established law firms. Also, like if you're new on the market, this will be a great chance for you. If you are find a wise use of these technologies. Just give you an example. Just imagine a law firm in the 1990s who would decide, oh, we don't believe in all this computer stuff. I have my secretary and she's writing letters on a typewriter. I mean, where are they now? They would be gone. So you need to adjust it, and now you have a chance. You have a competitive advantage towards the older generations, that you will have it a lot easier to implement these technologies into your daily business, being how to scan through documents, or how to find a legal conclusion, or even how to connect with clients like what we do.
Thank you so much, Julian. Olivia, I'm going to ask you to use less than a minute.
Yeah, I wanted just to comment on what my colleagues have said. There's this social media. There's also, of course, there's content, but what we need the most today is the high AI literacy. Yes, everything what we find on the social media needs to be assessed and know if this is the right content for anyone, be it in justice, be it in education. Because our younger people, they're using data that they get from the internet. But all of this data is not genuine. So there's a component that needs to be emphasized, which is the adoption and the literacy. Thank you very much.
Thank you. Thank you, Olivia. Kenneth, did you want to say something? Now,
first, I wanted to respond to what my other panelists had mentioned, and I think it also really touches on the question that you've asked me. Look, I'm a little worried when we have discussions about artificial intelligence, and then, specifically when we say, don't worry. Because you see, I think with AI use, we're looking at it from two perspectives. One is the side of regulation, and the second is the side of use. Now, these considerations that we're talking about, these ethical considerations and so on, they are here for a reason. We are worried about them for a reason. I think one of the things that has really caught us off guard, but it shouldn't have, is like the issue of climate change. Climate change, scientists have been talking about climate change for many years. But now, because things are getting worse, we are seeing it in our homes, we're seeing it even in places where we're not causing as much contribution towards the damage to our environment as in other jurisdictions, is now where we're scrambling to find regulation and to be able to do that. Now, if these guys that have created these tools are telling us, look, worry, and then we're saying, no, let's not worry. I think as the lawyers in this room, I want people here to be hungry, first of all, on the side of regulation. Can you be among the people that are looking into regulating these tools? Because now that also goes to the use, and especially the question you asked about data. artificial intelligence leverages a lot of data. Data protection and privacy is now such a key and main or major topic for many governments all around the world, and specifically Africa as well. Every East African country at the moment has a data protection regulation or is in the process of creating a data protection regulation. And that is important because artificial intelligence and all these tools really leverage data to be able to provide or to be able to use to provide the services that you want them to be able to provide. Now, if we don't regulate these things, if we don't look into the harm in terms of these tools collecting all this data, that is going to be a big risk. I'll give you just a practical scenario as well. I was struggling this week with finding space on my computer. For those of you that use Mac, there's a section that has other storage, other than the breakdown in your computer. If you just go to your hard drive and check the different breakdowns of that data. Now, I couldn't find what was in other. But then I got an app that was able to clear my computer, and it then told me that most of the space that I had there were cookies that were kept on my laptop. Now we think about these things, cookies, should we click, should we accept, or just accept them not knowing that they're, the effect is that they're taking up the storage on your computers. They're tracking you, they're taking this information somewhere. And without regulation, it's going to, that's how we're going to make many of these companies richer, but without maybe some of this money coming to Ugandans, to Kenyans, to Rwandans, to Tanzanians, to Burundians. Because the question is, and again, these are discussions that we're having, should things like data have their own intellectual property rights? Should we regulate them to a certain extent that perhaps you guys, who they ask you, should you accept cookies and are using your data to be able to sell to you things? Should you have some money in your pocket as a result of the advertising or millions of dollars that they'll make in this particular aspect? So I feel we need to balance the discussion either way, on the side of regulation and on the side of use as well.
Yes, Olivier. In the meantime, we'll take focus
to this element of regulating AI. For me, it's too early to regulate this stuff. Because we don't know yet what is AI and what is AI solving now. Because if you want to regulate AI, let me take an example of how we've been regulating other sectors. Now we have GDPR. That was the model of most of our countries for the data protection. The European Union has tried to regulate AI. So far, they have failed, right? They are still looking at the way they can regulate AI. They are trying to either regulate the use or the application. But the AI itself is not so far easy to regulate. Because AI, what is AI? It's a set of technology in a system there to solve an issue. But if we regulate AI today, what would be regulated? That's my question. So I think now we are in a time to first learn about AI and see what is the potentiality of AI in each individual country. Let me explain this one. The content we have in Rwanda may be different the content we have in Burundi. And the AI, which should be developed in Burundi, may be using the data that is in Burundi. Or elsewhere, we'll be using the data from someone else who is not in Burundi or in Rwanda. For example, who among ourselves have been using ChatGPT? By the raise of a hand. ChatGPT. So few of us know about this artificial intelligence. But whenever you use this app, you get a content which not necessarily coming from your area. Which means the better we develop a robust data system, the better we use artificial intelligence in our way. So that's how we keep regulating. I think for me, the best way to regulate AI is to wait until we see the way it works and develop, and regulate it after. So instead of regulating this before. Thank you very much.
Thank you very much. I think the Q&A session is...
I'm trying to segue with other questions. I may not remember them all because I don't have artificial intelligence. But one, Philip, talking about lawyers and where we are. Look, when my brother here asked the question about how many of you have used ChatGPT, it's a worry that we didn't see many hands coming up, and here's why. Tools like these will make you work faster. Now, it is true that you need to be careful using them. You also need to be more watchful in how you incorporate them into your daily work. But there are other lawyers that are using them. And as we know, time as a lawyer, this is your tool of trade. Now, if you have a tool that's able to shorten the time that you're going to spend writing submissions, writing judgments, writing opinions, you free up that time for more work. And if you have a firm that's using artificial intelligence, that's using ChatGPT to be able to do that, they're going to have more instructions more than you, because you're going to struggle. You won't have this work-life balance thing that we're talking about, because you're going to always be working. And look, this culture of working up to 3 a.m., 4 a.m. and you wake up at 6 is because we're not using these tools, ChatGPT and the like. And the truth is that we are going to be left behind if we are not serious about trying to incorporate these tools into our practice. Now, that also brings me to the second question here, or proposal. In the sense that if we also don't regulate, if we are not looking into being able to see how to use these tools well, ethically and all that, the challenge is that other jurisdictions are going to go further than us. If you try now to check, there are many AI tools, many AI legal tools that are incorporating a lot of case law, contracts, etc. And so you find that perhaps tools that are in Europe may be more efficient than a tool that's in Nairobi, that's in Uganda, that's in Burundi, because one, our judges don't upload their cases online. So that's a challenge, because as I've said, you're going to have a disparity. And that disparity, first of all, will start within us, with the lawyers that use these tools and the lawyers that don't. There's going to be a bigger income disparity. But then also, generally, worldwide, you'll also have the disparity from lawyers in a particular region, because we don't have this jurisprudence online. We can't be able to automate it in a manner that will allow us to be able to use it well. The truth is, AI is here to stay, so can we learn to be able to use it? And I'll end with the frameworks. We're talking about regulation here, and I just wanted to read for you just the different frameworks that we have on AI. The recommendations on ethics of AI by UNESCO, recommendations on AI by OECD, Declaration of Ethics and Data Protection in AI. WIPO, I think, also has a working paper on AI. Google does, IAF. So we may not have regulation, but at least we have think tanks, we have regulators that are setting up policies. As we have an evidence-based approach to regulation, I don't think the answer should be don't regulate. I think the answer should be, as we wait and see, let's make sure we have frameworks that are able to look at things like coder bias and things like that perhaps we can discuss at a forum where we have more time to be able to look at them. Thank you.
Right, thank you. Yes, Olivier, 1 minute, please.
Yeah, I think, let me conclude by saying that there's two ways to use AI. You either be a user or a provider. So, being a provider, you need some key priorities. I think for me, there is an importance of having a high AI literacy, computer capacity, robust data strategy, and adoption, and widely beneficial AI adoption in the private sector, because the private sector is the one to feed AI most, and ethics of behind AI, because without AI, without ethics, there will be a wrong use of AI, especially in our sector of justice. So let me go back to the question that was asked by our friend from Burundi. For me, the way I interpreted the question is more of the use of social media, not the AI, because AI is supposed to support or to help those preparing for the election to know about the outcome of the voting by checking how frequent the voters are using there's a set of things that they consider, or the machine consider to give as a recommendation of who is going to be voted, rather than the content which is displayed on the social media. So for me, that's more of a social media content which needs to be built the way it is supposed to be built, other than the AI as itself. Thank you very much.
Thank you. I'll give the last two speakers 30 seconds and just conclude. Just conclude the remarks, please.
Thank you very much. Let me make a few comments in as far as the question that was asked by our colleague from Burundi is concerned, to do with the use of social media and the content we put out there when it comes to the dispute to do with elections. The reality is, in my short presentation, it was like lawyers and young lawyers especially, be careful about the content you're putting out there. Whether it's in elections, whether it's in while you are expressing your opinions on social media, be careful. Because tomorrow after tomorrow, you do not know how far it's going to affect your practice. It does not mean you do not have strong opinions that you want to express and tell the people out there, but be careful about the content you put on social media today. Of recent, there is someone that was complaining about being harassed at work in Rwanda. Then on Twitter, I jumped and said, you know what, I want to get in touch with you so that we see how we can be of help. And someone came down and he was like, are you doing client solicitation? For me, I looked at it as someone that was being harassed and I felt like, can we help? But then the next comment was like, hey, Mr. President, are you doing the client solicitation? That is one of the examples that you can see that is, I mean, it's something I never take time to think about twice. So I think those are the comments I can make. And when it comes, especially now into politics and the elections, lawyers have their positions. It's true that you can express your opinion, but also look beyond that very period of elections as a lawyer.
Yes,
and think twice. Thank you.
I think being the last in line to sum it up, I can make it easy. For me, it's basically two discussions in the same field. One discussion is how do we deal with AI and these kind of technologies now, and my plenary would be take the chances. There are a lot of chances especially for young lawyers to implement these technologies, but at the same time, as my colleague just said, you have to be very careful what you do because this technology can also be a bit overwhelming. That's one discussion we had. And the other discussion is basically how to regulate AI and when to regulate AI. I think everybody is in agreement that we need to regulate it. And the question is just when is the right point to do it? And my colleagues pointed it out, there are discussions going on. The only thing which is probably difficult at the very end, and we'll see how this develops over the next 5 years, is this first mover thing. So somebody, if you would have a big economic power, I don't know, China, US, European Union, having a really solid AI regulations, there's a high chance that others will somehow orientate themselves on that. So the question is, if I would be one of those superpowers, when do I come out with a solution? Because when I get out too early, I might not cover issues which we don't see right now. So I think that's why we need more time to discuss these things on various levels. And I think we, as lawyers, we need to raise our voices because we know how these structures can work. We know how to think in these kind of structures, and I think we're needed there, so we need to be open-minded. Thank you. That was hopefully short.
Thank you very much. I think there will be further sessions that will serve as a follow-up to this. I hope now you know that your means of getting your ugali, your ipiharagi, your asedi, and all these things are not compromised, but rather you can use them, you can use AI and legal tech to ensure that you're getting this, you are getting your daily earnings even more than what you're getting now. Otherwise, thank you so much to you all, and I'd like to invite Elizabeth to give the vote of thanks.
Right, thank you everyone for paying attention throughout the session, for the questions, and a big thank you to the panelists for making time and even coming to have this conversation with us. As my co-moderator has said, we need to have further discussions of this. Maybe the chair of the tech committee can take that up. Thank you.
And this is a young lawyers event where the young lawyers, 1 to 5, raise up your hands. 1 to 5. I can see there are a few young lawyers and many young lawyers at heart. Thank you. My name is Omwanza Ombati. I practice in Kenya. I'm a young lawyer at heart, though I've practiced for 20 years. I also mentor young lawyers as a people master, and I'm glad that I have seen a number of them who are here. Today we have a distinguished panel to have a discussion on cross-border legal practice. We have Honorable Dr. Justice Michael Mutambo. I was once an assisting junior counsel at the International Criminal Tribunal for Rwanda between 2005 and 2010 in a case known as Military One, which was a case that involved accused persons who are accused of bearing the greatest responsibility in commission of crimes against humanity. And as a young lawyer, I think I was then 1 year, I was able to learn about the processes of international humanitarian law and criminal law, and it's an experience that I've carried along in my life as an advocate. And it's always a different experience when you practice this in these international tribunals or whatever forums that adjudicate over these matters. I'd want to go first with Justice Kayobera. I hope I pronounced it well. Sorry, Justice Mutambo. I'm sorry for that. Maybe you can go first and just have maybe a 5-minute or 10-minute presentation so that members have an idea about what happens. Yes, maybe you can come this and stand here. Thank you. A clap for Judge. Thank you very much.
Thank you. Thank you very much, colleagues. I'm also a young lawyer because despite my age, this is the first gathering I have attended on this subject. And I was supposed to talk about the COMESA Court of Justice. That's why I sent my PowerPoint. And I was told, no, you have to talk about young lawyers. So I couldn't refuse, I had to accept. And I spent the last 3 days here in Bujumbura doing some research on the subject matter of cross-border practice with the assistance of our young court assistant from Uganda, Anthony. He works with us. So we have a couple of young people. We grew into our organization. That's another area where young lawyers might look towards in terms of their profession of practicing cross borders. And I'll just briefly talk about COMESA and how it relates to the subject of cross-border practice. Because cross-border practice for young people, you practice in a jurisdiction which is not yours. And therefore it has to be movement of services from one jurisdiction to another. And there are always restrictions, and national jurisdictions want to protect jobs. They think people from outside will take them away, not knowing that their side will also benefit crossing on the other side. So in COMESA, we are trying to make it easy for cross-border service provision. COMESA, can you build the PowerPoint? Where's my IT person? Okay. So COMESA, brief history, was established in 1981, first as the preferential trade area for Eastern and Southern Africa, a PTA. It was transformed into COMESA in 1994. So I here that the PTA Bank was here at first. It's a building which is somewhere. I passed its idol. The bank has been moved to Kenya. And that's also an area where young lawyers might seek ways of performing as legal counsel. And the Commercial Court of Justice was established in 1998 and expanded in 2004 into 2 divisions. All right, and the member states are the following. So you find that all the members of the East African community, except Tanzania, which moved sometime later. South Sudan is not a member. But on the left, you see the DRC Congo there. There's Kenya. On the right, you find there's Rwanda and there's Uganda, who are members of COMESA. So the rules that we set up in COMESA to improve cross-border legal practice also benefit these countries which are in East Africa and the members of COMESA. So, cross-border practice for young people poses serious challenges. When you move from one country to another, you're going to encounter different systems of law, so you have to master different differences there. There will be cultural differences, and also you find that it will be necessary to help young lawyers to go through those hurdles and challenges by giving them mentorship opportunities where experienced lawyers assist them to get into the maze. And networking is important to young lawyers to navigate the system. Although it's difficult to network when you have different time zones, but there are always ways of getting around a problem. There are all those challenges, cultural differences, differences in ecosystems, which are there. And as I said earlier, normally national jurisdictions want to protect their turf. When I was doing research on the net on this subject, I discovered there was something from Uganda. One time in Uganda, Parliament passed a bill to open up the market for lawyers to come from outside, young lawyers included, to practice in Uganda. And there was uproar, surprisingly, from the Law Society of Uganda, while opening the floodgates like this. And so anyway, I'll be interested to know from our Ugandan colleagues what happened and what is the current position with respect to that problem. Right, and what I'm supposed to talk about essentially the practice, the hurdles, challenges of cross-border practices for young lawyers. And I have said already that there are these challenges. Mentorship is a challenge. It's difficult to find people to mentor you in your development, but that has to be addressed. Complexities of legal systems, I talked about that earlier on. And the need to promote cultural sensitivity among the young lawyers. Different people have different cultural sensitivities. I remember yesterday I was discussing with my colleague from Egypt, Justice Rami, sitting there in the Commercial Court of Justice, improve the movement of people, because as Commercial, we are a regional economic community, and we try to improve not only the movement of goods from one person to another, liberalizing movement of goods, but also service provision. And the framework for opening up is Article 164 of the COMESA Treaty. And then we have got 2 protocols which deal with the subject matter. It's protocol on the free movement of persons. Actually, the first one is the protocol on the gradual relaxation and eventual elimination of visas, adopted in 1984. And there's also another protocol on the free movement of persons, labor services, right of establishment and residence, adopted in 2001. So these two protocols provide a framework for the progressive removal of barriers of movement. And how have the protocols been implemented? COMESA member states have made varying progress in implementing the visa protocol, and all countries except Mauritius and Seychelles have ratified this protocol. So there's a three-step movement. So the countries have sort of promised to remove visas upon arrival, have visa-free entry for up to 90 days, and then eventual removal of all restrictions. And then the free movement of people has not yet entered into force, that protocol, with only Burundi and Rwanda having ratified it. So it's a dream that we're going to be one, going back to the old days, where one people, the borders were introduced by colonial people. And the eventual idea of the RECs, regional economic communities, is to build towards the African continental free trade area, not only in goods but also services. So cross-border practice by young lawyers is an aspect of liberalizing service provision in the region. So the benefits of the way we want to go, although we are not yet there, if these protocols are implemented fully, we have more economic integration and social integration, and also last but third bullet from the bottom, there will be provision of services across the border, which include the legal services, the cross-border legal provision of services by young lawyers. The challenges there are that lack of awareness and the wait and see attitude and so on. Now, I want to conclude by honing in on the subject matter that I was asked to talk about, which is the cross-border legal practice. This presents a myriad of challenges for young lawyers, necessitating a strategic approach to mentorship and professional development. By addressing the complexities of legal systems, promoting cultural sensitivity, and facilitating meaningful networking opportunities, the legal profession can better prepare the next generation for success in the global landscape. Efforts to enhance mentorship and professional development will contribute to the cultivation of a cadre of adept and globally aware legal professionals. Thank you very much for listening.
Thank you, Judge, for that presentation. I hope you have your questions ready.
Good afternoon, young lawyers and all others who are young at heart. I just wanted to share with you two areas of practice One is international arbitration, the other is mediation. At the advent of industrial revolution, with which we started seeing manufacturing, trade and commerce setting in, and the dispute resolution which was closely following all these activities was adjudication. Court system was the one which we adopted as a platform for adjudication and dispute resolution. Closely followed by that, when we saw clogging of the court system, we saw adjudication moving out of the court system, introducing thereby something called arbitration as dispute resolution mechanism. With increased globalization, with increased trade and commerce, we saw arbitration practice going international, and particularly with the support of the New York Convention of 1958, we saw the arbitration practice picking up internationally. When I say this, if I have to speak within what is happening within the African continent, we have at least three major regional centers. One is the place where we are staying, which is East African Community. Similarly, we have SADC in Southern Africa, and ECOWAS in the Western Africa, and few others. All these formations are only towards helping the cause of trade, commerce, socio-economic change, and the legal practice. And with the national bars equally supporting them, we started seeing the international arbitration picking up in Africa. Continuing with what my predecessor said, and with what yesterday we heard from Peter Maynard with regard to the 10-point agenda with regard to cross-border practice, education and training. Yesterday Justice Rao was referring to an institute in Nigeria. All young lawyers would be equipped when the doors are knocked to take international practice as arbitration. We have seen the regional centers emerging within this region. The other day we saw the National Center, International Center for International Arbitration in Nairobi Center for International Arbitration. Similarly, we have Kigali International Arbitration Center in this region, and then few others across various other regions. These are the support mechanism where young lawyers' attention is drawn toward international arbitration, and with the support of national bars and support of various law firms internationally which are located in this area, one can easily look for an international practice, international arbitration practice as a mechanism where you cross the border seamlessly. And from the process of adjudication as dispute resolution mechanism, today we are slowly moving towards a process to find out the ways and means of settling the dispute. And that's where mediation entered its sphere. In the recent past, it has caught the attention of the world. It is widespread in the United States of America, and started slowly percolating in other parts of the world. Thereby, if not today, tomorrow, mediation as a practice, cross-border practice, started assuming importance, and with education and training in this particular field, as a number of centers across Africa and beyond started training mediators to get into this process of adjudication of settlement as a better way of dealing with disputes. The other day we saw how the Nairobi Center was getting up and has started already training mediators. And with the advent of the resolution of the United Nations 2018, followed by the Singapore Convention, which took place in 2019. The cross-border mediated settlement will get legitimacy. It gets implemented in your respective jurisdictions. We always get to hear Africa as a country. Africa consists of 54 nations, but the fact remains, once every country in Africa signs and ratifies the Singapore Convention, Africa in reality can become one country. African Union in the year 2013 set an agenda called Agenda 2063. If you have to call out one word from that process, they say integration. Integrating the entire Africa as one country. And when mediation takes place with the approval of Singapore Convention signing by every country in this continent, the mediation process of dispute resolution will gain importance, and young lawyers can get ready by getting or entering into this area of adjudication, this area of dispute resolution, where the disputes can be resolved very amicably with ending of happiness with one and all. So these are the few thoughts I just thought I'll share with you. Thank you very much for this panel.
Thank you very much, President. I'd want to invite Dr. Adrian Njuko to have maybe a short 5-minute presentation about his thoughts about this area, and then we conclude with Wanjiku Rubia. Okay, I am advised to change. Wanjiku, if you can present 5 minutes.
Good afternoon. Young lawyers, good afternoon. I understood this session to be a call to you to take action, because it's up to you to take action to cross those borders, physically and virtually. And that's what I want you to appreciate about the East African community. I believe you all have blue passports. That is an initiative of the community, the 7 countries that are there, probably except for DRC. So there is a way that you can actually practice, and it is happening across borders. I represent the East African Court of Justice in Arusha that has been there for the last 20 years. Come to Arusha and practice. Does anybody do you have a practicing certificate? Are you licensed to practice in 2023? Then you're a candidate to come and practice before this international tribunal, which is treaty-based. So as long as you know the rules of the East African Court of Justice, you are acquainted with public international law and treaty interpretation, you are a candidate to practice at the East African Court of Justice. And also, you can come in as amicus curiae. Keep yourself acquainted with the cases that are coming to the court, because you can very well come in and say, I have expertise and I would like to be a friend of the court. So there's that opportunity, as long as you're practicing and licensed in your home country and you are competent to go before your superior courts in your national country. The other thing you could come and do, even where you are, as you're contracting, as you're formulating the commercial contracts, put in a clause and say the jurisdiction to arbitrate can be to the EACJ, and that is an opportunity for you. Put it in your contracts and come, because the court can be an arbitral tribunal for you. We have 12 judges, and of those 12 judges, they will create an arbitration tribunal, and those cases will move on. And also, we have a mechanism now where we are moving from country to country. Sit in the session. We are going to be in Kigali, the Lord willing, in February or March next year. And you will have the opportunity of the court sitting in Kigali. You can come in and understand it. And even if you cannot come physically, once in a while, the court does what you call live streaming. Just go and Google, or we have a website there, live streaming. You can actually learn, take the initiative to learn about this court. Because without knowing our jurisprudence, without knowing our rules, without knowing how it operates and who is competent to come before it, you will not be able to cross that border. That is one way. So it is a personal initiative of all of you. And also, you can do something collectively. As the bar associations, you have an opportunity to actually make sure that the barriers that exist for cross-border practice come down. The East African community has what they call the Common Market Protocol, which allows free movement of people, of goods, of capital, of services, of workers. And it is up to you to get acquainted with that protocol and to use the mechanisms that are there. As I tell you, in 2011, the lawyers decided to try and get into what they call a mutual recognition agreement to allow cross-border practice. They formulated a draft, and at the point of, and that process went on. They discussed it to and fro until 2016 when it fell through, because they were unable to come to an agreement. As Justice Matambo has mentioned, we have different levels of, we have diverse legal systems, we have different capacities even coming of advocates and practicing lawyers. Some countries have the 10,000 and above, others have 5,000 and below. And what we know is there is nationalism, there is protectionism, and it is the bar associations, as we have heard, who are a hindrance at times to even the cross-border practice because of competition. But what you need is competition rules as well, because already it is happening. I picked up a brochure this morning of one of the firms that have been able to have, networks, partnership, branches. So they are in 5 countries or 4 countries, and that is an initiative you can do. Here you can network, and you will know that if I come to Bujumbura, we have somebody in Bujumbura, we can have somebody in Kigali. So even if the rules are still under development, there's no hindrance for you to actually be collaborating across borders. Another way you can lobby is actually, as we speak today, the East African community is trying to come together with mutual recognition regulations, so that if you are a certified lawyer in Kigali, certified in Uganda, certified in Tanzania, there are a certain set of rules that will allow you to actually go across. But remember, you have to be conscious of the tax regime, the work permit regime, the immigration rules, and so many other factors. As we speak, there is a draft, and that draft is being worked on. And you can push for that, you can advocate. We've heard of advocacy. So if the bar associations are actually serious, there's an opportunity to be advocates with their ministries of justice, with attorneys general, with the Ministry of East African Community, with your TRA, with your revenue authorities, who will tax you. Because movement of capital is also something, but it is something that is allowed. So I think there's opportunity to do something alone, with your own initiative as an advocate, and to do the collective as well, so that you talk to your ministers, you talk to your attorneys generals, who are actually now probably hindering the movement of not just the lawyers, but also others. But let me give you the example. Sometime back in the same period, around 2011, 2012, the engineers, the architects, the accountants, the veterinary people, the bodies that regulate the professionals, they came together and they came up, they formed what you call mutual recognition agreements. This is what the regulatory bodies have done. It's not working very well, but they're trying to still overcome the barriers, because they are still barriers. The engineers will be our case example. Please track down engineering, because engineering will be the next frontier that will show us an example of how you can cross from one border to another and do work across. So I think there are opportunities out there, and it's up to each one of us to actually grab those opportunities and talk to your governments, the regulators, and see how you can push it. And even as you talk, you're also using the technology. I enjoyed that session on technology because at the end of the day, virtually you'll be able to actually work, collaborate virtually using IT and the other mechanisms. Thank you.
Thank you, Wanjiru, sorry, that's very thoughtful. I'd also now call our last presenter, Dr. Adrian Juko. Short thoughts about this. Let's have a clap for him.
Thank you so much, moderator. My name is Adrian Juko. I'm from Uganda. I teach law at Makerere University, but also I'm the executive director of Human Rights Awareness and Promotion Forum, which is an organization that basically works on human rights issues. So then why am I here? The reason I'm here is because I've done cases before the bodies that they've been talking about. So we've brought so far 2 cases before the East African Court of Justice. Well, with mixed results for that, but at least we brought them. And basically it's a good avenue to practice law. And also we brought a case, now this is not a court, but the working group on arbitrary detentions at the UN level. We brought it and always in many ways are like a court. And then that would also require services of lawyers. But also we planned cases across the border in different countries on different human rights issues. So my call here for you today as young lawyers is how to engage in cross-border litigation that is across the border in other countries, but also in regional and international bodies and organs. I've had about 15 years experience of doing this, and so I know how it works. But also, I'm not speaking about different other issues, I'm speaking about mainly human rights, because that's the area in which I work. So I'm going to talk about the opportunities that do exist within these bodies, but also the challenges, not just opportunities, because whenever there's an opportunity, there certainly is also a challenge. And I'm going to say it from a very practitioner-based perspective. Now, in terms of opportunities, what we have are the bodies and organs, they do exist. They have talked about them. So it's up to us to use those bodies. If we don't use those bodies remain essentially useless. So we, the lawyers, have to use the bodies for the bodies to work for us. If we don't go to the COMESA court, if we don't go to the ESCJ, then that means these courts won't be working. So it's important for us that we use them because they do exist to serve us and serve to make them useful. Number 2 is there's an ability within the law for us to bring cases, especially human rights ones, across borders. If you come to think of it, in Uganda, our constitution allows any person to bring an action for enforcement of human rights in the courts of law. I have a feeling that actually a Kenyan can come and enforce this in our courts of law, and why not? And then why wouldn't a Ugandan also do it? The Uganda wouldn't do it perhaps because of limitations in space, shifting space and other things, and other challenges that come with occupying tax spaces. So that would mean that we get colleagues from Kenya or Tanzania to come and do human rights cases in our own countries, which I think is something we should explore and try to do. So that things are difficult. Maybe someone who is not within the country may be better place to do this kind of case for us, and that's another opportunity. The other opportunity is that for those who are interested in money and how to make money, maybe there's some man at the end of the day in this kind of litigation, even though it's for human rights. Human rights law does not exactly have a client who may be rich enough to pay you, but at the same time, if you do it well enough, there are people who are willing to support cases across the region. So at the end of the day, it may not be as lucrative as other areas of the law, but certainly there is some money that you can make at the end of the day when you're doing human rights work. So it's not entirely free all the time. You can make some money. Now, those are the opportunities, but there are some challenges. Some of the challenges have to do with what I call NGOization of human rights work. That most of the work that we do as human rights lawyers is done within the framework of NGOs, and this is partly because of the cost implications. NGOs have the ability to look for money and raise it, which you may not do as an individual. So it's quite difficult for a young lawyer to enter into that area without being part of an NGO. And yet NGOs come with their own politics on how you can do things and how you can do cases. So maybe we should think of ways of going outside NGOs and still be able to do cases. Another challenge is the expense. I know there are some e-processes that you can use, but still it remains costly to have to go to Arusha for the ESCJ, or to go to Kigali for that matter if we're in Kampala, or to go to Nairobi if the session is there at that time. The same thing with the UN. You have to go to Geneva for most of the sessions that you have to do, and this is quite expensive and costly. So we need to think about the challenges, and that's why for most of the time it's not African lawyers who work in these areas, but other lawyers from other jurisdictions because of the issue of expense. And then of course there are challenges that are inherent in international law, especially around the issue of enforcement. When you get a decision at the ESCJ, how is it enforced? I know it's enforceable, but how is it in reality enforced with countries looking at human rights as an area that we shouldn't be engaging in? So, and also the inherent weaknesses within the bodies themselves, which kind of decisions they can make and what happens to them. For example, so what happened with the SEDEC tribunal when cases that were controversial were taken to the SEDEC tribunal. So these are things we have to think about as we think of cross-border litigation and practice, but also working with such bodies. But for me, most importantly for young lawyers, please join us in the struggle for human rights. At the end of the day, all the other things we work on, they have to be based on human rights and rule of law and good governance. If we don't think about human rights, good governance and rule of law, then in my view, you won't have any legal practice left if all the things crumble to the ground. So this is an area we should work and look at as lawyers, and more especially as young lawyers. Like I said in the beginning, there's also some money to be made if you do it quite well and you become patient enough. Thank you so much.
Thank you very much, Dr. Adrian, for that presentation. So we will have maybe 3 questions that we want to be raised from the floor or from the delegates. But in summary, if I may summarize for you this presentation, from my understanding, cross-border legal practice largely involves a qualified advocate performing legal professional work beyond his or her home state. That's my understanding of that. Number 2, this arises out of the concept of about free movement of goods and services. I think you'll find this in the relevant protocols that have been signed by countries. Number 3, in Kenya, currently there is a proposal for the amendment of the Advocates Act, Section 12 and 13 of the Advocates Act, to allow advocates from Burundi and Rwanda to be able to practice law in Kenya. This matter has now gone through, I think, the first reading in Parliament, and it's now been submitted for public participation by advocates and other members who are interested in this. So very soon we would be seeing you colleagues coming across, and we'll be happy to host you. Silvio, thank you. Now, so there is that movement. Then the issue that Wanjiru raised about the blue passport. The blue passport allows you, of course subject to other limitations like tax and things like that, for you to cross the borders. She also raised an interesting point that I have not thought about. She said that there is, in the contracts that we do, the commercial contracts we do, you can actually put an arbitration clause for a dispute that might arise from the contract to be adjudicated by the court, the East African Court of Justice. One of the bars about this cross-border practice is nationalism. It's also in our country, and I'm sure in the other countries, that we feel that there is competition that will be coming from the other bar association or from members. So these are two. So the challenge is, 1, on advocates in your personal capacity to be able to pursue these opportunities, and 2, for the bar association of our respective countries to be able also to engage. And Dr. Njuko also spoke about money being made. I'm sure this is very important for lawyers. Silvio, normally if you want to make a lawyer happy, when you take a photo, you must say fees. So instead of saying cheers, you say fees. So may fees be with you. So fees is an important consideration for lawyers. So there is a challenge. There is also an opportunity to make money. So I will submit now for questions before the delegates. We would have 3 questions, and then we can close the session. Daktari, if you can pass the mic.
I have the mic. My name is Brenda Ngalo, and I have a question and a comment. So the first question will be, what they have spoken about the challenges that the courts, the regional courts face, and most of them end at implementation or enforcement of the orders that they do make. What is being done to address those challenges? Because those are challenges that have been there since these courts were established, be it understaffing, be it enforcement and all that, but particularly enforcement. What mechanisms are being employed to make sure that that is done? Then the second one, what would be, how difficult would it be to maybe create an AFCTA but for legal services? Because in as much as the borders, we talk about the borders being open, the regional integration and all that, we still see even in other areas of trade and all that, there are progressions that are being done to make sure that the movement of goods is smooth, movement of revenue and all that. We see that there's something that is being done. Can we have a similar thing being done for legal services? Thank you.
Enforcement of orders by the courts. The practical enforcement of the orders of the court across the states. I would give that to Judge to be able to respond. The second question was about the language. Language barriers between Francophone and the English speaking. The third is the system of law. I'm just summarizing the issues that have been raised. The third is the systems of law that operate within our countries. So in Kenya, for instance, we have the civil law, the common law, and then in Rwanda and I think Burundi we have the civil law. And lastly is about the movement of goods and services. I think I've summarized that. Maybe each of the panelists can have a minute to respond, and you'd have a session during lunch break to be able to also ask questions. Thank you.
Or orders of the court, particularly where they impose a pecuniary obligation. You can take the judgment and enforce it just as you do with any foreign judgment. You go to your registrar of your court in the domestic regions and you can register the judgment of the regional court. Thank you. But of course, if member states are not complying with some issues, then they can be taken by the Secretary General or even a legal person can go approach the court. In our case, under Article 26, where natural or legal persons can approach the court to enforce the observance of obligations by a member state or by the council. Thank you.
As regards mediation is concerned, once the country signs and ratifies the Singapore Convention, you automatically agree to enforce the cross-border mediated settlements. So that's how this legal regime works. Everything depends on each country signing and ratifying the Singapore Convention. So that's the basis on which enforcement takes place. Thank you.
Okay, Brenda, you asked about enforcement. I will not add to Justice Matambo's what he has said. It's similar, but I will refer you to cases where there is non-pecuniary. When countries are put under pressure, they are forced to comply. 3 cases, Professor Nyong'o, BAT case, and Kyo. You will see that countries actually tried to amend their laws and regulations just to ensure compliance, and it happened. My brother from DRC, yes, there is a need that has been realized. DRC is the newest baby to the community, and this baby has to be taught, they have to awareness has to be created, and I believe in the coming months and years, you will see a presence of the court and even the community as we try and get you up to speed about the treaty and everything that pertains to the community. In terms of a question of language, I think there was my brother at the back, linguistic integration. Kiswahili, French, and English are the languages of the community. And while English was first, there is a development of Kiswahili and French that is underway, just to make sure that all these people actually understand one another as one people. The other thing I want to probably address, and probably my brother will address, is why we don't have a criminal jurisdiction at the court. It's a treaty court, treaty-based interpretation, and you have to claim violations. I believe my brother will go ahead. And then remember, the community is heading towards a monetary union and eventually a confederation. That is the vision. It may take 20 years, but that's the vision. And the vision is eventually you will be able to move freely, trade freely with a common currency. And that needs to be borne in mind. And as we speak today, the Kenya shilling, the Uganda shilling, and the Tanzanian shilling are directly convertible. So it's up to the other countries, Burundi, Rwanda, RSS, and DRC, to come to speed so that even as trade is done, the convertibility of currency also applies.
Thank you so much. I'm going to quickly discuss the issue of enforcement, but from the perspective of the lawyer. That's also our role as lawyers to ensure that decisions are actually enforced. Our role doesn't end at getting a decision from the court, but also we must make sure that we force enforcement through the different mechanisms, including going back to the court and demanding that they ensure that this is enforced. And on that issue, I'm going to talk briefly about the human rights jurisdiction of the ESCJ, that we've been able to bring cases through creatively going around the issue of the absence of a human rights jurisdiction. This was established since the case, Dr. Tabaz's case, some years back. So you can still do that. And then my final point, and in closure, I would say human rights enforcement is not for the faint-hearted. Sometimes it comes with even personal risk. A colleague of ours in Eswatini was recently murdered. A lawyer was murdered. And so this also means that we have to go, when we know that there are consequences to this, it has to be done. Thank you so much.
Thank you, Dr. Adrian, and that will be the end of this presentation. Please, a clap of applause for the panelists, and I think this has been a very interesting session. For those who want to ask questions, you can ask during the lunch break. The panelists are still with us. Asante sana, and have a good afternoon.